and welcome to the Zonta Club of Santa Clarita Valley's Life Forward Workshop, Divorce, Family Law, Child Custody, and Child Support, presented by Denise Light. I am Beth Heiserman, president of the Zonta Club of the Santa Clarita Valley. If you have any questions today during the presentation, please type them in the chat. Please send any of the questions during the presentation to the submit question here in the chat. To make all of our guests feel comfortable today, while this is recording, we have privacy settings. Feel free to click on the stop video to disable your camera. This presentation is going to be recorded live on Facebook and then uploaded to our website. Please feel welcome to share this with friends and family. We are requesting that everyone remain muted. It will only record the host. And now I present Phyllis Walker, Chair of our Life Forward Committee.
Welcome everyone to our Divorce and Family Law, Child Custody and Child Support Workshop. It gives me great pleasure to introduce our speaker, Denise Light. Denise has practiced family law since 1997 and is a certified family law specialist. This means she has gone beyond standard licensing requirements. Whether it's divorce or custody, property division or spousal support, her analysis of situations based on knowledge of rarely used case laws are designed to maximize her clients' rights during the process. She has been designated super lawyer each year since 2013, based on peer recognition and professional achievement. Her above and beyond education in the field of family law has given her a reputation for providing her clients the best representation within her purview. During the pandemic, formulating parenting plans with so many uncertainties and schooling options, parents are fighting over custody more than ever. In-person school, virtual, or both is a hot button topic that divides many households. With virtual capabilities for court appearances, what used to be a 5-minute hearing that required waiting an hour in court has been eliminated by these proceedings. Hearings that usually cost a client $1,000 are costing $2,000 now. And now, Denise, the stage is yours.
Thank you, Phyllis. First of all, I'd like to welcome all of you to Zonta's event today. My name is Denise Light. I've been a certified family law specialist and have practiced family law since 1997, as Phyllis said. And I like people to get to know me a little bit before we dive on into the educational aspect. So a little bit about myself. I'm one of 4 siblings. My father, my uncle, my brother, and my sister-in-law are all attorneys, all practicing in different fields. People ask me all the time, when did you know you wanted to be an attorney? And to be honest with you, most people don't believe my answer, but around the age of 4 or 5, I would hear my dad and my uncle debating. And obviously I didn't understand the concepts that they were talking about, but they were on different positions on the issue. And they were both so passionate and they were both so firmly believing in their position. And I thought to myself, I don't know what they're talking about, but they're really into it. And so I remember it was always at Thanksgiving and Christmas dinners where they'd have these esoteric legal discussions. And so from a very young age, I saw their passion. And then I ended up going to school to be a teacher. And I was in my second semester, senior year, student teaching. And one little boy was pouring glue on another little boy's head. And my instant reaction was to grab him and say, "What are you doing?" And I knew at that moment teaching was not for me. You have to have a very special heart of patience and gold to be a teacher. And I thought, man, this is not my career path. And so I went to my counselor and I said, I don't think I have the patience to be a teacher. What should I do? And he said, I don't know. Why don't you take the law school exam? So I went to law school. And I was married at the time, and my husband was like, "You argue with me for free. This is so great. Go out and get paid for it." So I did. So that's a little bit about my story. I've lived in Santa Clarita Valley now for 10 years. I used to live in Woodland Hills. Um, I'm a step parent to 2 boys. Hunter is graduating from San Diego State next month, thank God, and Toby, who's 14. So I know what co-parenting is like. I know what it's like to be in the trenches as an advocate, but also as a parent. So with that being said, first of all, let me give everybody the assurance that it's 10:10. At 10:45, we're going to take a predestined bathroom break because nothing is worse than squirming in your chair. So at 10:45, we will take a 1-minute bathroom break to let everybody stretch their legs and use the ladies' room. So we're going to start with an overview of the divorce and legal separation process. One of the very first questions people ask me all the time is, well, what is the difference between divorce and legal separation? It's a very easy answer. The process is exactly the same. The paperwork is exactly the same. The arguments are exactly the same. The only difference is at the conclusion of a legal separation case, you cannot get remarried. And at the conclusion of a divorce case, you can get remarried. So sometimes people come to me and they say, well, I think I just want to get separated. And I explore that option with them. And I say, well, you realize that if ultimately you get legally separated, and you a year from now decide it didn't really work out, you want to get divorced, you have to go through the whole process over again. Double time, double money. And legal separation was a concept that was kind of developed in the late 30s, 40s, and 50s when divorce had a religious, moral kind of cloud over it. People didn't want to get divorced for religious reasons or societal reasons or family reasons. So this concept of legal separation came to be. And so it's really the same exact process, except like I said, at the end of your legal separation process, you cannot get remarried. You are still a married person. You are just separated. And at the conclusion of your divorce process, you can get remarried. So that's the difference. So what is the life of a divorce case? A divorce case has a beginning, a middle, and an end. The beginning of a divorce case starts with the filing of a petition, which is a request that the judge dissolve the status of your marriage and make any other decisions that you ask the judge to make. The judge can't randomly make decisions. You have to make requests in your petition for the judge to make orders on, let's say, child support. You have to request that the judge make orders for spousal support. You have to request that the judge do something with your house. You have to make these requests in the petition. That is your request document. Once you file your request document and it comes back, we have 30 days to serve that on the other party. It can be done by a process server or by a neighbor or a friend. The party who files for divorce or separation cannot serve the other party. And then once the other party served, they have 30 days to answer. That's the time given to them to go find an attorney or go find a paralegal or somebody to help them. Some people take all 30 days and you're waiting on pins and needles for them to file their answer. And some people respond the very next day, but they do get 30 days to answer. Within that 30 days, the filing party has to complete their declaration of disclosure. The declaration of disclosure is like the foundation of a house. It is all of the financial information that each party knows about their assets, their debts, their credit card liabilities. It is the foundation, and it gives the judge the baseline information of what is in the pot to divvy up or to assign. And there are very specific timelines and time rules for the declaration of disclosure that need to be met. If they're not met, the judge can actually issue a monetary sanction. It's a fine for people who don't complete their disclosures. usually the judges will give you an opportunity like, hey, you haven't done your disclosures, it's time to do them. I'm going to give you one last chance, and they'll set a drop dead date. But the declaration of disclosure is 8 pages. The first 4 pages is what's called an income and expense declaration. And in that income and expense declaration, whether you're employed or not, you need to let the judge know when you were last employed, how much money you earn if you're a salaried or hourly employee. And then you list all of your expenses. And the common question that people ask when completing their income and expense declaration is, well, if I list my expenses as higher, will I get more money? And the answer is no, you will not get more money. The support is based on a guideline calculation, and only certain expenses go into the calculation. So, exaggerating your grocery expense by $500 a month, or your auto insurance expense by $500 a month is not going to do you any good in your support case. It's also going to make the judge very, very mad at you, because the other side's going to say, oh, you pay $1,000 per month for groceries, prove it. And then if you can't prove it, then it's clear that you've inflated your expense. So you want to make sure your expenses are as close to reality as possible. You don't have to go through your checkbook or your Quicken or your online banking accounts to make sure that it's to the penny. But I would say an error, a margin rate of 10%, plus or minus on the estimate is within the acceptable range. So you always want to take your time, complete your income and expense declaration accurately. And we're going to talk more about the income and expense declaration in a little bit when we talk about support in full. You're also required to produce your last 2 months pay stubs with your income and expense, because the pay stubs have a lot of information that we use when calculating support. The second 4 pages of the Declaration of Disclosure is called the Schedule of Assets and Debts, and this is the big one. It takes a lot of time. It's akin to completing a home loan application or a refinance application. It requires a lot of attachments. Most people can get it done in a day. But basically, you need to list all of the assets that you own. If you own homes, you need to list the address. You need to attach your mortgage statement so everybody can see how much the principal balance is on the mortgage, how much you owe, what the percentage rate is. Same with your car. You'd have to list your cars, attach a copy of your registration statement, attach a copy of the payment billing statement. And you do that for 4 pages, all of your credit card statements, all your bank statements, all of your investment statements, all of your statements for your personal financial statements. And so those documents form, again, the basis of what there is to divide in a divorce case. Truthfulness and accuracy on a declaration of disclosure is probably like the number 1 of the 10 commandments of family law. People think that, I have this box of cash that I have under my bed that nobody knows about. I'm not going to list it. Well, if the other party knows about it and you didn't list it, it becomes a very big problem for you. So I'm going to tell you guys a little story. This is fun. I like to play the lottery. I don't know about you, but I love the concept of the lottery. So 15 years ago, there was a divorcing couple, the Rossis, and they were getting divorced. And during the pendency of their divorce, Mrs. Rossi went to a liquor store and bought a lottery ticket. And sure enough, she won $3 million. Well, she did not disclose her winnings on her schedule of assets and debts. She just thought she was going to play it on the down low. She was not going to list it. And she had all of communications between the lottery and herself directed to her mother's house. She selected the payment over time option, the annuity option, and she was going to have all annuity checks mailed to her mother's house. So they go through the divorce process, and poor little Mr. Rossi is sitting in his apartment, and he starts getting these letters from insurance companies and annuity companies that say, hey, we want to buy your lottery winnings. And he's looking at these notices in the mail, and he's like, this must be sent to the wrong house. And so he keeps getting like this junk mail. So a couple months later, he receives a call on his telephone and, hi, congratulations on you winning the lottery. We want to offer you a cash buyout. And he started a conversation with this gentleman and he said, why do you guys think I won the lottery? I did not win the lottery. Well, sir, that's not true. Your wife won the lottery. And he's like, what? So this third-party solicitor informed him that his wife had won the lottery, and he immediately picked up the phone and called his divorce attorney. And he said, hey, I think my wife won the lottery during our divorce. Something's up. I've been getting mail for several months. I just talked to this guy. He told me that she won the lottery. So his lawyer went into court the next day and got an emergency court order freezing the California lottery from making any payments or corresponding with Mrs. Rossi until this whole issue was sorted out. Well, true enough, Mrs. Rossi had won the lottery, and she did not disclose it on her declaration of disclosure. So when it came time to explain herself, she then tried to claim, well, my mom gave me the money to buy the ticket, and so it's my separate property. Well, the judge humored her and said, well, even if you thought that it was your separate property, you were still required to list it, and you could have identified it as your separate property and explained why. The fact that you didn't list it makes me think that there's something else. So they had a very contested trial over the lottery winnings. And instead of Mr. Rossi receiving his 50% share of the $3 million, the judge awarded him 100% of the winnings, and Mrs. Rossi got nothing. And that is because the declaration of disclosure and the requirement of transparency in divorce proceedings is so paramount and is so important that she got nothing. And the family code actually says that if a party intentionally does not disclose an asset, the other party will not get their 50%. They will get 100% of the value of the undisclosed asset. So it is extremely dangerous to think that somebody won't find out. There's always, everybody who watches CSI knows you never get away with anything, whether it's a criminal act or a civil act or something in the family law case. So when I tell people to do their disclosures, I tell them it is very important that you be accurate, and I'd rather even have you over-report something that maybe shouldn't have been included than under-report something that definitely should have been included. So declarations of disclosure are extremely difficult to make sure that they're accurate. There is a breach of fiduciary duty claim in family law cases where, if you don't disclose things, you can be fined substantially by the judge. So declarations of disclosure are the foundation. Okay, so once everybody does their declaration of disclosures, that's when the horse trading can begin. What do I mean by horse trading? Well, California is a community property state, and that means that the community, the total value of the community, needs to be divided in half or as close to half as possible. Well, you can't cut a house in half. You can't cut a car in half. So the declarations of disclosure give us the information so we can make sure that the half of the total estate is allocated between the parties. So that may mean that one party gets the house, but the other party gets more in pension money to make up for that share of the house. So we always try to get values as close as possible, which is why the statements to the declarations of disclosure are required. So it's not just somebody going, oh, I owe $200,000 on my house. No, you don't. You owe $299,000, and we need to factor that in to make sure that everybody gets their equal share of the pie. The division of the community property assets does not have to be in kind. For example, houses, especially in this real estate market, houses have an extreme value. You know, houses right now, at least in my cases, are being listed and there's, 60 offers, 180 showings. One of my clients, who's also a realtor, had an open house last week and they got an offer of $200,000 above asking price after 60 showings. So the house is a very hot item right now because they're going for a lot of money right now, and so there's a great market for value. Once we deal with the house, I try to deal with the house rather quickly. And as a tip for all of you listening, houses do not have to be sold prior to trial. A party cannot go into court and say, I want my house sold now. Houses have to be valued at the time of trial unless the parties agree to sell it now. I always try to encourage people, hey, the real estate market's really great right now. If we go to trial in a year or two from now, you may be leaving a lot of money on the table because the real estate market could tank a year from now. The economy could tank a year from now. Like, why don't you pull your money out and sell it now? So houses are a time of trial asset. Other accounts, pension, investment, banking accounts, are a date of separation asset. So we ask, when is your date of separation? And we ask you to gather statements for your date of separation. Why is that asset as of the date of separation? Well, account balances fluctuate, but people also usually contribute to their 401k, their IRA, their retirement after the divorce process has started. And those would be called separate property contributions. So the other spouse doesn't get any credit for that. So we want data separation for retirement, investment, banking accounts. Same thing with credit card debt. Credit card debt is valued at the date of separation. So even if you have a spouse who has a credit card and you know nothing about it, and you get their declaration of your disclosure and you go, oh my gosh, I had no idea they had an American Express card and that they owed $17,000 on it. Oh no, they didn't owe $17,000. The community owes $17,000 because it was incurred during marriage. A lot of people think that that's a very unfair result. Hey, he or she has this credit card. I knew nothing about it. Why do I have to be responsible? Well, that's part of the benefits and burdens of marriage, is that anything that is accumulated during marriage to the good assets or to the bad debts are community property. So in a lot of cases, people are figuring out that there is more community debt than they knew about by virtue of them looking at the declarations of disclosure. Okay, so let's talk about support. Support is a very hot button issue right now, especially because of COVID, because many people's earnings have changed. They've either changed for the better. For example, if you're a mortgage broker, you were worried about COVID, but refinances have gone through the roof. And so if you're a mortgage broker, your income has probably shot way up. And if you're like, the rest of us, you may have experienced a drop in your income, which would affect support. So generally speaking, child and spousal support can only be ordered back to the time that it's requested. So what does that mean? That means if you file your petition for a dissolution of marriage and your attorney does nothing, and 6 months go by and you've run out of money and you say, hey, I need child support and spousal support, what are we doing about that? You will get it from the time it is requested. So it is important that you communicate with your lawyer, you tell them where you're at financially. In some instances, it can go back to the date of petition, but that's very rare. But you need to get a child and spousal support order going if you're finding yourself in need of funds. When people have reduced income due to COVID, For example, many people have lost hours. Many people have been laid off. Many people have, you know, gone on unemployment. If you have experienced any of those changes, it is important to get that on record, so that the judge is aware of your financial situation. Verbal agreements about child support and spousal support are great. It indicates a level of cooperation between the parties. However, they are not enforceable. So if you and your spouse agree that he or she is going to pay X amount of dollars per month, and they go ahead and they do that, and then on month 5, they decide to stop, you do not have a court order, unless it is reduced to a stipulation. So verbal agreements don't count. There is a formula for determining child support and spousal support. There are computer programs. The one that I use and the one that most judges use is called DissoMaster. DissoMaster is a court-approved software program where you put in the income and the certain expenses of the parties that we talked about, and you itemize the number of children that are involved, and it's a complex mathematical equation determined by the Judicial Council of California, and it spits out a number. And those numbers are what we call temporary or pendite lite. That's a fancy Latin term. Pendite lite, temporary spousal support and child support. Once that's ordered, the judge will sign it, and then it becomes an enforceable order, so that if somebody stops paying, you can garnish their paycheck, you can bring a contempt proceeding, you can do one of several things. The court cannot determine permanent spousal support by using the computer program, and we'll talk about that later. But the computer program is just for ease of use for the attorneys and the judge to start a support order rolling when the case is new. People always want to know, what does child support cover? Like, well, let me break it down. For my male clients, the common complaint is she's not using the child support for her children. She's getting her hair done or getting her nails done. And my standard response to them is, you don't get to micromanage how your ex uses her money. So you have this child support order, you pay it. That is the extent of your obligation. You don't get to criticize, micromanage, or determine how that money is spent. The child support payments are to be used for food, clothing, shelter, other necessities for the children. Generally, in my experience, child support, it depends on your standard of living. Child support can be oftentimes more than sufficient to provide for the needs of a child, and oftentimes it can be grossly insufficient to cover the needs of a child. Having kids these days are very, very expensive. And if you have, a 9-year-old who goes to 4 birthday parties a month, man, it starts to get really expensive really fast. So, the support recipient is, going, wow, this child support really doesn't cover that much. And it's true, it doesn't. So it's always good to, have your lawyer work those types of things as add-ons to child support. Birthday gifts is probably not a great example, but, the cost of graduation, cap and gown, yearbook, senior trip. What about when your kid starts driving? Who's going to pay the cost of the car? Who's going to pay the cost of the insurance? For safety, don't we all agree that our kids should have a cell phone at some age that we should both pay half of? So you can negotiate, and you should negotiate certain add-ons to the child support so that your kids' needs are met. Graduation is a super expensive process for seniors these days, and both parents should be involved in that. It shouldn't be on the person receiving support to front the whole cost of that simply because there's a child support order. So it's important to have clear communication about that. spousal support. People always say, well, how long am I going to get it, and how much am I going to get? So there's what we call the 10-year rule in spousal support. What does that mean? Well, the state of California has determined that if you have been married for 10 years or more, congratulations, you have a long-term marriage. 10 years doesn't seem long-term to me, but I guess in Hollywood land, 10 years is a long time. And if you pay attention even slightly to Hollywood or those types of things, you'll hear that Tom Cruise and Nicole Kidman got divorced in the 9th year, 10th month of their marriage. Russell Crowe got divorced in the 9th year, 6th month of his marriage. All of these super famous people, super wealthy people are getting divorced in the 9th year of marriage. Well, why would they do that? Because when you hit 10 years, there is a presumption of a very significant support award for life. And so these people have quality lawyers, and they're like, hey man, we can't get to the 10-year rule. It's going to be very, very expensive. If your marriage is on the rocks, or if it's rocky, we might want to consider doing something because we're approaching a precipice here. So 10 years is a long-term marriage in the state of California. When I talk about lifetime, that really depends on your age. So let's break it down. If you get married when you're 20 and you have a 10-year marriage and you get divorced when you're 30, is it likely that the judge is going to order you lifetime support from the age of 30 to 90? No, that is not likely. At 30 years old, you're young, presumptively young and healthy and able-bodied to work. You have a 10-year marriage. Is it going to be lifetime? No. Is it going to be for a substantial period of time? Yes. So, a lot of people get hung up on this lifetime. Now, let's use my same example. Let's say you get married when you're 45 and you get divorced when you're 55. Is it likely that you're going to get a lifetime support order? Yes, more likely. Why? You're older. Maybe you haven't been in the job market that long. Maybe you have health conditions that prevent you from working 40 hours a week. So it's all fact driven. So 10 years can mean a lot to somebody who's 45 and can mean a lot less to somebody who's 30. So the 10-year, people do talk about the 10-year marriage, and it definitely is a thing. And it's, if you believe that you may be a support payor in your relationship because you out-earn your husband or your wife, you definitely may want to consult with somebody if you find yourself in a situation where you may end up paying spousal support. What goes into spousal support, and how do we calculate that? Spousal support is really easy to calculate when two people are W-2 employees of some company. They get a W-2, they get a pay stub. It's super easy. The math almost does itself. Where spousal support becomes murkier, not impossible, it becomes murkier where there are self-employed people or 1099 independent contractors. I was telling Beth before we started that I really wish colleges and high schools would give a class to people on how to read a tax return, because so many people come into my office and they have no idea what line 17 on a Schedule E even means. They don't, and it's not their fault. 99.99% of people don't know how to read a tax return, but tax returns are super, super important in family law cases because they tell us, where there may be other sources of income, and they tell us if we should be adding back income out of expenses. So self-employed people, business owners present a much more complicated set of facts for calculating support. And usually what we do is we assess the tax returns, and if necessary, we engage the services of a forensic accountant. What does a forensic accountant do? A forensic accountant goes through and traces the income and the payments in and out of the business for let's say the last 2 to 3 years. And most of the time, like, for example, I'm self-employed. I run a lot of my expenses through my business. My cell phone expense, I run through my business. My car expense, I run through my business. Well, if I was a W-2 employee, I wouldn't be able to do that. So the expenses that I'm running back out of my business are added back into my income. So we add back self-employed expenses into income, and that is what's called cash available for support. I've seen a lot of tax returns and I've seen a lot of funny stuff. You know, people writing, self-employed businesses writing off their gym memberships, their health insurance, their cars, their educational travel to Hawaii expense, you know, where they went to some seminar. Lots and lots of expenses get run through a business, and all of those will get pushed back into the income column for everybody to calculate support. Now, granted, 100% of those expenses may not be appropriate. For example, your car expense, yeah, you use it for work, but you also use it for personal. So maybe 50% of that expense is pushed back into the income. So we want the accountants to determine the cash flow available for support. That is with the self-employed spouse. The forensic accountant will also determine, if asked, what the marital standard of living is. Marital standard of living, a lot of people think that that is something that is involved in every case, and it's really only for the super higher end cases where, you know, people are traveling private jet, people are going to Europe 3 to 4 times a year, people are, you know, driving new Bentleys every 2 years. I mean, so marital standard of living, sometimes people do their Google lawyer search and they're like, I'm entitled to my marital standard of living. Well, most of us live a working class, middle class lifestyle. And so marital standard of living truly does not really apply. I mean, it does to some extent, but not a lot. The forensic accountant will also do a community property balance sheet, which identifies the value of assets at the correct time. They'll do a spreadsheet. I do those for my clients too, just so everybody can see what exists. So going back to the cash flow available for support. If you are filing your divorce or thinking about filing your divorce after 2018, the Tax Cuts and Job Act makes spousal support no longer taxable to the recipient. Prior to 2018, the payor got to deduct the amount of spousal support off of his or her taxes, and the recipient had to declare that as income, and that created taxable income for the recipient. Well, the Tax Cuts and Job Act came and that changed all that. So now the support payor does not get to deduct spousal support, and the recipient does not, they still have to claim it. They just don't pay taxes on it. So that is a new tax law that affects divorces going forward. If you have an old divorce judgment prior to 2018, you still get the benefit of deductibility or taxability, whichever side of the coin you are on. Some people say, well, wow, that's really great. I don't have to pay taxes on my spousal support anymore. Yes, that is great, but the amount of spousal support that you would get is now decreased because the tax impact was taken into account. So most people are kind of surprised when they hear their spousal support number, and that's lower than it normally would have been because of the tax deductibility issue. This is it's 10:43. I said we were going to take a potty break at 10:45, but this is a good natural break for us. So we're going to take a quick coffee refill warmer potty break for 2 minutes, and then we're going to come right back. So I'll see you guys in a minute. time. Lawyers are run by the clock, so I'm always very conscious of everybody's time. So we're gonna carry on. Before I move into the child custody discussion, I want to talk about how COVID has impacted the courts and what you can expect. The courts were closed for about 6 months. There was literally 0 court appearances happening. Everything was being continued. So you can imagine the 700,000 active cases in Los Angeles County literally being placed on hold. And all of those hearings for 6 months got pushed into another date, which is happening right now. Courts have opened up selectively for in-person court appearances. Funny fact, the Los Angeles Superior Court had not updated its computer system since 1962, prior to COVID. And no joke, we are the largest Superior Court system in the country with the oldest computer system in the country. And so when COVID hit, literally the wheels came to a screeching halt because they did not know what to do. And they realized that this infrastructure that they had been putting off for 40 years, 50 years had to be done immediately. And the reason that, in all fairness to the courts, the reason that they were not able to do that is because the Judicial Council gets very little funding from the state of California. Shockingly, courts are very low on the totem pole of priority for funding. But when COVID hit, they knew they had to do something. So they literally did 50, 60 years of upgrades to the LA Superior Court computer system in 10 weeks, which is a monumental task. And a lot of lawyers were experiencing extreme frustration with that, but the kinks have now been worked out. We have a program called LA Court Connect, and any litigant can access LA Court Connect. It's $15 if you are uncomfortable going to court in person due to COVID concerns. You can appear in all family law cases by video, which is, I mean, if you would have said this to us a year ago that the LA Superior Court would have had this capability, we would have literally fallen on the floor laughing because they don't even have electronic filing of documents. So now LA Court Connect allows lawyers and litigants to appear by video if they so choose. Some court appearances you must appear in person. For example, if your spouse has filed a contempt against you, you must appear in person to get arraigned. That's a very rare occurrence. So LA Court Connect is really great, and it's really great for clients. Number one, if you have childcare issues and it's hard to get away to go to court for 3 hours, this really eliminates that. You can stay at home and appear by video. Funny note to everybody online, the people who I can see on video all have great backgrounds or professional backgrounds. I had a client appear on LA Court Connect. To my horror, he literally had like a giant nude Renaissance woman painting, like literally above his head for his court appearance. And I was like, oh my gosh, oh my God. Like I had to text him like, dude, change your background. Like we can, there's 100 people on LA Court Connect looking at your background. So it was just a funny little story. But the great thing about LA Court Connect is, like I said, for people with childcare issues, it eliminates them trying to find a babysitter for 3 or 4 hours. It eliminates time sitting in traffic. But it's so much more cost effective because you're paying your lawyer from the time that they leave their house to the time that they get back to work. That could be an hour each way in travel time to downtown LA for your court appearance. Well, that's eliminated. So right there, you've already saved $1,000. And so LA Court Connect is really great because it's saving the clients a lot more money for court appearances than they would have experienced prior to COVID. There are some hearings where I always tell my clients we can go or we can appear by Court Connect. My personal philosophy is that on issues of child custody and support, I want to be there in person. I want the judge to see me and hear me. And quite frankly, the judges kind of have the attitude, well, if I have to be here, shouldn't you have to be here? I mean, they don't have that attitude, but it has to affect them, especially when they see people who aren't prepared, sitting in their pajamas at home, distracted. So I would highly recommend on child custody hearings that people go in person. And again, if you have a COVID concern, everybody respects that. Judges respect that, not a problem. So LA Court Connect has been a really great development. It also allows the attorneys to see minute orders online, which we've never been able to do ever. We're getting close to electronic filing, which seems so silly that we even have to look forward to that. Like that should be a thing already. But for attorneys to file papers, we actually have messengers. We actually have court runners who stop at our office every day at 10 o'clock. They pick up all of our papers and they take them to all of the various courts, whether it's Chatsworth, downtown LA, Ventura County, we have runners, which seems so silly in this day and age, but pretty soon we're going to get up to electronic service. And again, that will save the clients money. So that's a great, I call it like the silver lining of COVID. So LA Court Connect, really great development for judges and attorneys and cost saving measure for clients. All right, let's talk about custody. Custody has been greatly affected by COVID. When COVID first, when the lockdown was first announced, everybody just kind of froze and nobody was quite sure what to do. And with uncertainty about how severe this virus is or could be, people kind of panicked about exchanging their children with their spouses when they weren't sure if their spouses were social distancing or taking the proper COVID measures to protect themselves. And so it became a hotly contested issue. And the courts started getting bombed with, people not complying with their custodial orders, saying that the other person wasn't being COVID cautious and all of that stuff. And so it's a new world for all of us, for lawyers and for judges. It's basically a case-by-case analysis on, what is in the best interest of the child. Starting back from the beginning, there is a presumption of joint legal and joint physical custody to two parents. When a case is filed, a judge comes into a case going, okay, these people should have joint legal custody and joint physical custody, and that somebody needs to change my mind. Then that's usually where the fight starts. So what is joint legal custody? Legal custody is decision-making. Where should our child go to a doctor? Where should our child go to school? Should our child get a driver's license? Should they be issued a passport? Should they receive mental health counseling? Should they, be enrolled in, should they do acting? Should they become an actor, a child actor? Legal custody is decision-making. Generally speaking, courts award joint legal custody. And if it turns out that somebody is obstreperous or is withholding consent unreasonably, a judge can change legal custody to one parent, or they can give one parent sole decision-making authority. So usually the case is, the parties have joint legal custody and mom is trying to get dad's consent to take the child to an asthma specialist or something like that. And they keep asking for consent. And the father or the other parent is like, no, and I just don't want to do it. And if it's obvious that their withholding consent is unreasonable, the judge could give the mom sole decision-making authority over medical issues. But you have to show a pattern of unreasonableness of the other party. So that's joint legal custody. Physical custody is, where should the children live? Where do they live? And a lot of people come into my office and they say, well, I want 60-40 custody, or I want 70-30 custody. And if you were to say that to a judge would say, I have no idea what that means. Custody is not determined in percentages, it's determined in schedules. And so judges really do not like when people say, I want him to have 10% custody. Well, what does that mean for your kid? We don't know what that means. So it's always a good idea to have a schedule in mind, days of the week, weekends on what you would like to have happen. Generally speaking, unless somebody is a terrible, terrible parent, or unless somebody has a work schedule where they go to work at 4 a.m. and they can't take the kids to school, a judge is going to order substantial, frequent, and continuing contact with that party if they can meet the requirements of it. I have a lot of clients who say, I want half of the week and alternating weekends. And I'm like, okay, let's look at your work schedule. When do you get up? When do you have to be to work? Can you take them to school? Can you pick them up from school? Can you take them to soccer? Can you take them to oh no, I can't do any of that. Okay, well then you can't have half custody because you can't do the job. And I always tell my clients, don't ask for custody that you cannot implement, because then we'll be back in front of the judge trying to defend why we didn't take the time that we demanded in the first place. So physical custody is really a family by family, just not only decision, but a family by family event. No two families are the same. No two families have the same activities. No two families have the same work schedules. No two families have the same support systems. So you cannot compare your physical custody schedule to your neighbors. You cannot compare your physical custody schedule to your friends, because everybody has different issues going on in their life. Some people have spouses who travel for work. My ex-husband traveled three weeks a month. There was no way he could ever have 50-50 physical custody of our kids, even if he wanted to. He couldn't. His work demands were too great. He couldn't do it. And there are some people who don't want to acknowledge that their work demands are too great, and they want to continue the fight, and it costs an extreme amount of money. It costs an extreme amount of emotional energy fighting that fight. So legal custody really has to fit on what you guys are doing. It's best if the lawyers and the parties can sit down, whether it's in person or in a Zoom conference, and hash a custodial order out. Why is that best? Well, the parties know their kids better than anybody else. They certainly know the kids better than the judge. They certainly know, that little Andrew has a little quirk where he has to, read this specific story with one parent before going to bed to put him at ease before going to bed. All of those little things are important. They're important to that little boy, and they want to be considered in the custodial schedule. Sometimes, ideally, the parents and the lawyers can work out schedules that both parties can live with. That phrase is super important, what you can live with. If you fight for the perfect schedule or the perfect order, you're going to spend a lot of time and money, and you may be disappointed. But if each party just gives a little tiny bit from their best position, if they just compromise a little tiny bit and they say to themselves, can I live with this? You're more likely to get an agreement. And studies have shown that people are more likely to abide by the custodial orders that they created themselves, rather than one that a judge foisted upon them after reading their life story for all of 6 minutes between the 40 court appearances that they had on calendar that day. And I'm not joking. Ideally, judges read all of the court papers that we spend so much time and money preparing, that they are supposed to do that. But imagine being a judge. Imagine having 40 court cases that you have to do in a 6-hour period every day. Do you think the judge knows about little Adam's quirk that needs to be addressed? Probably not. He probably hasn't gotten to page 17, footnote 4 of your paperwork where you talk about that. And that's really important to you. And that's really important to your son. But these judges are really overworked. They have a very limited time. And they may not pick up on those little nuances. So I always try, in my practice, I always try to do, once the case is filed and once the financial disclosures are done, I try to put the financial disclosures aside momentarily, and I want to deal with the child custody. I want to come to an agreement if possible. Why? It's good for the kids. They need to know, kids like structure, they like a schedule, they want to know who they're going with, when, they want to know all of that. They don't want to be like, oh, your dad's showing up at school and yanking you out of school because he wants custody. Like, we don't want that to happen for your kids. So I always try to do the custody provisions first. It also does something else. It also prevents people from using their kids as bargaining chips when it comes to the property and the money issues. Oh, and it's happened, believe me. Oh, I'll give you more time with little Johnny if you give me the piano. Oh no, you don't ever want to say that in front of me, because that would make me super mad. People using their kids as bargaining chips is like the lowest form of parenting I can think of, but it happens all the time. So I want to do the parenting schedule to give the kids structure, to put their mind at ease, and to put the parents' mind at ease that nobody's going to show up at the school, nobody's going to show up at, volleyball practice and throw the kid in the car and not know where the kids are. So doing that first is really important. Okay, if you cannot come to a custodial agreement with your spouse, what do? You file a request for the judge. And it is a huge mistake to tell the judge every negative thing about the other person, and instead focusing on why the time with, like, focus on the positive. My plan would be good for Johnny because X, Y, and Z. Instead of saying Johnny shouldn't be with dad because of they're a horrible person, they're this, they're that. Show why your plan is better. Focus on the positive attributes of your plan and why that is in your child's best interest. Certainly, I'm sure there are things that would need to be addressed about the other parent's inability to co-parent, whether it's a addiction problem, a scheduling problem, a work problem, but start off with why your plan for yourself is better, and then dovetail into the other party is requesting this, and I don't think this will work that well because I have concerns about their drinking. I have concerns about their ability to get the kid to school on time. I have concerns about, doing homework, which is a huge thing. So start off on the good foot on your plan, and then talk about the failures or deficiencies in the other plan. Judges are going to make decisions on child custody based on what they believe is in a child's best interest. Everybody has a different opinion on what is good for a child. Using the most extreme example I can think of, some people think it's good for children to receive corporal punishment. Some people don't. That's the most extreme example I can think of. Some people think it's great for children to be in a household where they have to have tasks to earn money. Some people don't. Best interest is a very gray standard. Usually the judge wants to keep stability for the kids, going to a different house every other night. That's not going to happen. That's not great for kids. Living out of a suitcase is, imagine being that little child. Oh my God, my head's on a different pillow every night. Like, that's not great for kids. A lot of people ask me what I think is a great custodial schedule. And honestly, that depends on your kids. Your kids may be super independent, super strong-willed, super self-motivating at a young age, and they can handle being away from one parent or the other for a day or two. Some kids are extremely clingy to one parent or the other, and that's totally normal as well. But I'll give you like a general guideline. Anybody over the age of 9 or 10 is probably going to be on a 50-50 schedule with both parents. 50-50 schedule takes many forms. It can be week on, week off, Sunday to Sunday. Spend a week with one parent, spend a week with another parent. Week on, week off is, some people love it and some people hate it. Some people, the thought of spending 7 days away from their kids, that's not happening. And that's totally understandable. Some people like the 7-day on, 7-day off because they can cram all of their work into the weeks that they don't have the kids, and then they can, it depends if they what kind of job they have, but then they can spend their week on with the kids. So again, it just depends on the needs and wants of your family. So week on, week off is one variation of 50-50 custody. One of my personal favorites, regardless of age, is called the 225 program. What is 225? 225 is Johnny spends Monday and Tuesday overnight with mom, spends Wednesday, Thursday overnight with dad, and then they alternate weekends. Why is this a great schedule? This is a great schedule because, number one, it's easy for a child to remember. If they're in 4th grade and their little buddy says, hey, can you come to my party on Thursday? That child can think to themselves, every Thursday I'm with my dad, I need to ask my dad. It's a schedule that they can remember and articulate. So every Monday, Tuesday with mom, every Wednesday, Thursday with dad, and then you alternate weekends, Friday, pick up school, return to school Monday. That is a 225. I like that also because a parent doesn't go more than 5 days without seeing their kid on their off weekend. A variation of that, and I do not like this one at all because again, the kids can't keep track of it in their brain, is 1 week you have Monday, Tuesday, and then the alternating week you have Wednesday, Thursday, Monday, Tuesday, Wednesday, Thursday. So you zigzag through the month, and that way you only go 3 days without seeing your kid. That might be great for you, but it's probably not easy for your child to remember. But it is another variation of 50-50. You can also do midweek exchanges, on your week on, week off. Every Wednesday you exchange. A lot of times I've seen where people do the week on, week off, and then every Wednesday they spend that night with the other parent. So they're not going 7 days without seeing the other parent, and that works sometimes well too. But again, it all goes to what your child's needs are. A lot of conflict arises in transitions between households when sports equipment isn't remembered, school books aren't remembered, the laptop computers are left at the other party's house. The number of transitions that you have in your custodial schedule increases the likelihood of tension if something's forgotten or something's not done or whatever. So you always want to try and minimize transitions, or you want to put a clause in your agreement that if Johnny's soccer equipment is not remembered, it's the handing off parents' responsibility to go home and get it, not the receiving party's responsibility to handle that. And that way it's kind of an impetus to remember those types of things. But transitions of items between custody is very, very difficult, especially when you have multiple kids in multiple sports and in multiple activities. So you want to minimize that. Just so everybody knows, if you do file a motion for a custodial order, mediation with court services is mandatory. What does that mean? The courts provide a court mediator, usually a psychologist, that invites everybody into the room or everybody into the Zoom room, and they talk about they make suggestions, they talk about options, they provide ideas on a parenting plan. Why is this necessary? Well, the judges have so many cases that if they can even resolve 30% of them through mediation, that takes a lot of work off of their plate. So mediation is absolutely mandatory prior to the judge hearing your case. If you have and the lawyer set that up for you, of course, but if we set up mediation for you and somebody doesn't attend and we go to court, the judge is going to say, oh, somebody didn't come to mediation. I'm continuing your hearing for 4 months until you go to mediation. You don't want that. So you got to go to the mediation appointment when it's scheduled. Court mediators cannot talk about anything other than child custody and visitation. Don't bring up that, so-and-so hasn't paid you child support for 5 months and therefore they shouldn't be able to see their kid. They don't care about the money. They don't care about property. They don't care about support. They are not even allowed to talk about it. They are only there to try and get you to come to a custodial plan and a holiday plan. Sometimes that works, usually in 2 parts. We do the regular plan and everybody signs off, and then maybe they run out of time, so they go back and then they do their holiday plan. I always tell people, if you can come to an agreement and mediation that you can live with, do it. Don't do it if you don't like it, because it's very difficult for me to change once you've signed on the dotted line. But mediation is required. I mentioned this briefly. Child support has nothing to do with child visitation, in the sense that if your spouse hasn't paid you child support, you do not get to withhold your child from the visitation. That is probably the absolute worst thing that a parent could do, is to say, you haven't paid me, you're not seeing little Johnny. Judges hate that. They will come down on you like a ton of bricks if you do that. Yes, the non-payment of support is important. Yes, you need the money. Yes, it will be rectified, but you don't get to invoke self-help and withhold children because of financial issues. It's a very dangerous road to toe. Do not do it. There is a presumption of in child custody cases that a perpetrator of domestic violence should not receive custody of their children. That seems like a no-brainer to me, but it is in the family code that a perpetrator of domestic violence should not receive at least unmonitored custody of their child. Domestic violence cases have surged 800% in Los Angeles County since COVID. People don't have a way to escape. There have been many dangerous situations in Los Angeles County that victims of domestic violence have experienced. I've handled so many domestic violence cases, I can't even tell you. But there is a presumption against custody for a perpetrator of domestic violence. And by the way, a child is a victim of domestic violence when they hear or see their parent being abused. They don't have to be abused themselves to be a victim. If they hear it or witness it themselves, they are themselves a victim of domestic violence. Judges take that very seriously. I had a case in December that I went to trial on, and the father in that case threatened to break my client's legs and throw her down the stairs. And you hear the little 3-year-old screaming, "Don't break mommy's legs." And we went to trial in that case, and the judge found that the 3-year-old was a victim of her father's domestic violence against her mother. And she received a restraining order. A 3-year-old received a restraining order against her father. So there is a presumption in domestic violence cases against custody, which I think is a very good thing. If you are a victim of domestic violence, you do not have to be physically assaulted to be a victim of domestic violence. The code describes a victim as anybody who has had their peace disturbed by another party. And if somebody is emotionally abusing you, threatening you, demoralizing you, all of that can be a basis for a domestic violence order. Now, don't get me wrong. Don't go into court and say, well, Denise Light said that name calling can get me a restraining order. I am not saying that, but there is coercive control when it comes to finances. There is coercive control when it comes to movements in and out of the house. There's coercive control on electronics. If your spouse hacks into your email or your cell phone, they will have a restraining order issued against them. If I am holding my Starbucks cup and my husband and I get into an argument, if my husband grabs my cup, doesn't touch me, but grabs my cup forcefully and takes it out of my hand, that could be a form of domestic violence depending on the totality of the circumstances. If anybody needs assistance with domestic violence issues, there is a free domestic violence clinic down at the courthouse. They will assist you in filing paperwork. If you do not have the ability to hire an attorney, Neighborhood Legal Services in Glendale provides pro bono assistance for all legal matters if you meet their criteria. There's also a law firm called Levitt and Quinn, which is a completely pro bono law firm that provides legal services for low and no income clients as well, depending on qualifications. So we don't want anybody to feel like they don't have a way out, because there's always a way out. It may not be as quick as you want, but we want to get help to everybody who is in a dangerous situation for themselves or their children. Custody, corporal punishment. If you are a corporal punishment person, don't do it. Judges do not like corporal punishment. It has long-term significant impacts on children. Corporal punishment can be construed as abusive. And it is, listen, I was a child of the 70s and 80s. I was corporally punished all the time and I turned out great, but corporal punishment is not accepted by courts. Don't do it. This is a big one. Sleeping with your children. When children are infants, parents might choose to co-sleep with their children, which is fine. But when your child is 7, 8, or 9 years old, parents should not be sleeping with their children. Judges do not like it. I'm sure it's completely innocent, but it raises the specter of weirdness for a lot of judges. So it's super important that you do not sleep with your children. It's fine to lay in bed with them, to fall asleep with them, but then it's your job as the parent to exit the bed and go into your own bed. Co-sleeping with children is a very hot topic with judges. It kind of weirds them out a little bit. Okay, so Phyllis or Nicole or Beth, do we have any questions so far that we can address for somebody?
Yes, we do.
Oh, great.
Someone has asked if they have a 13-year-old, does he get to decide?
Oh, that's a great, I'm so glad that question was asked. Okay, whoever asked that, thank you very much. So 13 years old, the family code says that a child of 14 years or older has some say in the parenting arrangement that they live with. So here's the deal. 10, 11, 12, 13, 14-year-olds, they don't get to decide if they go to school. They don't get to decide if they go to the dentist. They don't get to decide if they're going to brush their teeth in the morning. Children don't decide. However, when children are age 14, which is the age where people, where the judges feel that, the child has now reached a sufficient level of maturity, they will hear from the child. How does a judge hear from a child? Well, a judge will almost never let a child come into a courtroom and testify. It's very intimidating for most people, certainly for a 14-year-old child. So how does the child's preference come into evidence? A couple ways. Number one, a parenting plan assessment is done, and the parenting plan person may talk to the child. Number two, a custody evaluation takes place. A custody evaluation is a very, very expensive procedure. Starts at around $7,500, can go up to $25,000, $30,000. And a custody evaluation deals with the parents and their relationship with the child, but the child gets to talk to the evaluator and the child's preference is expressed. Then there's minors counsel. The judge may appoint an attorney for your child, either at the cost to the county or to you, and the child will talk to his or her attorney and talk about what they like and what they dislike. So a 13-year-old child probably has some opinion. They don't get to decide. It's not whatever they say goes, but it's a great question. It's raised a lot. And so if your child has a preference, or if your child's not liking the schedule, I would say like, hey, why don't the three of you sit down and talk about it? Or if that's not comfortable for you, say to your 13-year-old, well, why don't you tell your dad or your mom that you want to try this and see how it goes? Now you may say, well, gosh, I'm putting my kid in the middle of that. If they're old enough to tell you what they want, they have to be old enough to tell the other party, because at some point they're either going to tell the judge through their attorney or through the custody evaluator. So the short answer is yes, they have some opinion. And great question. Thank you for asking that. Is there another question, Beth? No more questions? No? Okay. So I hope that you guys have found this presentation.
We have one more question.
Oh,
Sorry.
great. That's okay.
Sorry. If a father has been absent, never met the child, decided not to be in their life, when they found out mom was pregnant, is it possible for them to get custody?
Okay, so I'm confused about the question because they were never in the child's life, but then
Correct.
they found out the mom was pregnant. Can they now get custody?
Right. That's what it says. They want to know
Okay.
if they have
Uh,
any kind of rights afterwards.
Okay, so if a child is born and the parent has had zero contact, and this is actually true no matter how old the child is. If a parent has zero contact, zero email, zero phone contact, zero in-person contact, zero communication with the child, you can file a motion to terminate that party's parental rights. It's not an easy motion to do, but listen, if somebody is absent from a child's life, they're absent and you can terminate their parental rights. In this case, I think the question is if the child is born and the party has no interaction with the child, yes, you can terminate their parental rights and they don't have any say so. What's super important in that case is to look at your birth certificate if you've named the child's father or not. There's a presumption of parentage if you've named that person on the birth certificate, and then you would have to terminate parental rights. If there's no identification of the father or the other parent on the birth certificate, then you don't have to do anything. You would have to wait for them to establish their parentage to try and get rights to see the child. Any other questions that popped up?
We do. We have a
Yes.
couple now.
Oh, good.
I have one as well.
Okay,
Oh.
so we have one here. I'm going to continue and then I'll let Nicole as soon as I get through them. So here's another question. I've been divorced 6 years now. Stepmom is awful to my kids. Border of being emotionally abusive. This has put strain between my son and his dad. How does a step parent play into custody?
Good question. I'm a step parent myself. I I take the role as a friend to my kids. I'm not their parent. I don't discipline them. That's their parents' job to do. I'm really sorry that your children are experiencing difficulty with their step parent. I think it's hard for kids. It will affect their relationship. If your child is not able to have an open forum with his or her father to say, hey, I'm really feeling uncomfortable, or I'm really, I'm not happy with how this is going. You might want to consider having therapy between the father and the son, or family therapies to help him be able to express himself. It's really hard because judges really can't issue orders over step parents. I mean, clearly they can. If the step parent is doing drugs, then the judge can say that your child can't be in that person's presence. But when it comes to like emotional abuse or claims of emotional detachment or whatever is going on, judges really can't make orders that can rectify that. So I would suggest talking to your ex about maybe counseling or having a meeting between the three of you so that your son can express his concerns to both of you. That's the best answer I can give at the time.
All right, next question. What if there are different age children? Could there be a separate schedules ordered?
Yeah, that can happen. Separate schedules could be ordered. Judges really don't like to separate siblings though. There's strength in numbers. If there's any emergency situation, judges really do not like separating kids. Now, granted, if one of your kids is 17 and one of your kids is 4, there's likely to be a separate schedule. But if one of your kids is 7 and one of your kids is 12, that's unlikely. But yes, it could happen. Judges don't like it. There has to be a really good reason to do that. But yes, it could happen. Nicole, what was your question?
Yes.
How does domestic violence play into spousal support if the abused is the one that would be paying? It seems unfair to have to support them. And then there's an additional piece of it. Also, if you do not have proof, how do you proceed when it is well known in the family and friends of the abused person? Is it better just to not bring it up in the divorce?
Okay. So the first question, excellent question. There is a case on point on that. Abused spouses do not pay spousal support to their abusers, period, end of story. Makes sense. Unfortunately, it took a woman down in San Diego, massive. She was actually ordered to pay significant spousal support to her abuser. And she took it up to the California Supreme Court and she fought for years. And finally that became law. I don't know, to me, that seems like common sense, but yes, victims of domestic violence, if there is a finding of domestic violence by a judge, there's a presumption against paying spousal support. That is correct. The second question raised, domestic violence is very undercover. Most people don't abuse their spouses in public. So there are lots and lots of cases where it's very, very hard to prove. In the case that I talked about with the 3-year-old, the mom started recording interactions with the dad on her cell phone. If other people in the family and other people in the community know about it, how do you get that in front of a judge? They sign a declaration under penalty of perjury that has specific factual information, date, time, what happened, who was there, what words were said, what actions were taken, and they sign those under penalty of perjury, and a judge will read those and take those into account. So yes, you're right. Sometimes, most people don't walk around with a black eye. They walk around with a black heart that you can't see their damaged heart or their damaged psyche or their damaged finances. So you can get neighbors, family, and friends if they have only seen it themselves. It can't be, oh, she told me that this happened. They have to be with their own eyes or their own ears, see it or hear it themselves, and complete a declaration under penalty of perjury. Any other questions?
We do. We have, I think, about 5 or 6 more questions here.
Okay,
So-
just so everybody knows, I have to leave at 12 for another engagement. But I'm happy to do another session of this in another month for everybody. I just have another commitment at 12.
We should be okay.
Okay.
So our next question was very similar to Nicole's. Does DV get me out of spousal support if she makes more money than them?
If there is a finding of domestic violence by the perpetrator, then you will not have to pay, unlikely that you will have to pay spousal support to the abuser, correct?
My next question here is, they disappeared when they found out mom was pregnant.
Oh, that goes back to the prior question. Okay, so if they disappeared when they found out mom was pregnant and they've now had no interaction with the child, they can try and come back and ask for it. It's going to be very, very difficult for them to do that. Like extremely, extremely difficult. Listen, here's the deal. Anybody with $90 can file a request with a judge. It's whether that request is going to be granted or not. And so in that case where a child's been born and this person who the child, imagine thrusting a child into the hands of somebody they don't even know. That's a very scary situation for a child. So a judge is very unlikely to do that.
And our last question I have up here is, my ex just recently filed to adjust the spousal support and lied about me not making attempt to become employed. What can I expect?
Well, you can submit your own evidence on your attempts to become employed. You can submit your online job applications. You can submit your call logs to headhunters and recruiters. You can submit your LinkedIn profile showing that you're looking for work. You can submit your attendance at networking events to show that you're trying to make connections with people. There's lots of ways to prove that you are making efforts to be self-supporting and to earn a living. It's very important, if you haven't done all of those things, that you start doing all of those things and that you keep a detailed log, because judges don't like people who just sit on their butts and say, oh, pay me support. You know, the job market is tough right now. It's not out of the realm of reason that it might become difficult to become employed in this COVID age, but you got to show your efforts.
And
I don't have any more questions.
Okay. Any more, Beth?
Nope, that would be it.
Okay. I'm going to thank everybody for joining this call. I hope that you found it super useful. I'm happy to do this at another time for you guys. Just let me know. My office is located in Santa Clarita Valley off of Newhall Ranch and the 5 freeway. And if anybody needs to get a hold of me, my telephone number is 877-317-8080. Thank you all very much. I hope
have
you enjoy.
2 more. Are you possible able to do 2 more? They just popped up.
I will do 2 more. Yes.
Thank you. Also, I've been verbally abused constantly since divorce. Last time, just a few days ago, he denied it. Can I bring this up into court?
You can bring it up into court. I'm not sure if the judge will issue a restraining order on it, but you should document it. And yes, you should bring it up to the judge so that if it keeps occurring, you've established the prior incidences. Yes.
And our last one here is, are school loans acquired during marriage personal debt or community debt?
That's a very interesting question. It depends. So usually it goes to the person who incurred the debt. However, student loans sometimes are taken out in an amount in excess of the tuition and books, and people use it to live on. And so let's say your tuition was $1,000 a month, but you guys were taking $3,000 a month in student loans because you were living on the other $2,000 a month. That could be argued to be community. So it just depends on how much you took and the purposes of how the funds were used, but generally they go to the person who obtained the education.
And what is your phone number? Can you repeat that one more time?
Yes, 877-317-8080.
Perfect. And I believe that's it.
Thank you very much. I hope you guys have a great weekend and we will get together again soon. Take care.
You're
I
welcome.
wanted to say thank you, Dilly, for this wonderful presentation. You've helped so many today.
Oh, thank you for inviting me, Phyllis. I really appreciate it.
That was great.
Okay. And then I would like to move forward to our next workshop, which is actually in a week. It will be next Saturday. And it's Challenges of Motherhood, Recognize the Inner Wisdom, and Improve Relationships. Will be presented by Tosca Stepter. She is a training and development expert, and it will be to celebrate a day to honor mothers. So join us.
That's nice.
Next week, and we're going to have then 2 others in May, so we're booked.
That's great.
I like to add one thing that Cherise Moore, one of our attendees today, and a fellow Zontian, is sponsoring next weekend. So please join us next Saturday. And thank you very much, Cherise, for donating. Thank you guys for all attending.
Welcome.
So goodbye.